Go on your way.
No, forward will be warm.
Move down.
Especially getting all the way up here. All right.
Ready? Good morning. Thank you everyone for coming out today, especially on a holiday. I am Michele Sims, and I'm a candidate for Mulberry City Council District 5, but I'm not just here as a candidate today. I am here as a resident of Mulberry and someone who is committed to transparency, accountability, and the rule of law. This weekend, I and many residents across Mulberry were deeply concerned about a purported call of a meeting for City Council to be held tomorrow evening. This has been touted as an emergency meeting. Not only is the calling of this meeting illegal, it violates the Georgia Open Meetings Act, and it is a violation of the Mulberry City Charter. It is also includes items on the agenda that are also in violation of Mulberry City Charter. The 4 presumptive council members have no authority to take any action before the election is certified tomorrow. This intent to call a meeting is their attempt to subvert the law while also trying to be in compliance with the Georgia Open Meetings Act. They have failed in both attempts. The actions that they have taken shows that they understand the requirements of the law, while it also shows their willingness to violate the law. This is a violation of the trust that has been placed in them by the residents of Mulberry. Not only does it violate the Open Meetings Act, it violates the Mulberry City Charter. The City Charter clearly defines that emergency meetings are reserved for matters that affect life, health, property, and the public peace, and that can be addressed by the passing of an ordinance, none of which the stated issues can be addressed. Now, Michael Coker, one of the presumptive council members, and Doug Ingram, who is also a candidate for District 5 Council, have both come out in support of this emergency meeting. And they argue that it's necessary so that an attorney can be hired to address a court hearing to be held on December 4th. But this is a complete fallacy. The City of Mulberry, while the subject of the lawsuit is not a party to the lawsuit, the lawsuit they are referencing is being brought by Gwinnett County against the state of Georgia. The state of Georgia is fully capable, more than capable, of handling this lawsuit. They have voluntarily come alongside us to fight for the constitutionality of our charter in other lawsuits where they weren't even a party. So they understand the subject matter, they fought this issue before, and they have the deep pockets that are needed to fight this type of fight. Doug Ingram, in fact, in his statement indicated that these type of lawsuits are usually won by the party with the deepest pockets. Well, the state of Georgia has much deeper pockets than the city of Mulberry, and they are much more capable legally of fighting this fight. So there is no need to have an emergency meeting, to hire an attorney, and a lawsuit that we are not even a party of. There also has been stressed that the primary importance of this meeting is to elect a mayor and a mayor pro tem. This is also a direct violation of the city charter. The city charter explicitly states that the mayor and the mayor pro tem is to be selected at the first regular meeting after the election, not at an emergency meeting. Administrative duties have no place in an emergency meeting. Also, the charter, while it only states that the mayor is to be elected from among the council members, it is clear that it's supposed to be elected from among the 5 council members. That is what the residents of Mulberry have been told time and time again. And on the landing page of the cityofmulberrygeorgia.com, it states that the city will be governed by 5 council members and a mayor who will be selected from among the 5. So now they want to come back and say, we're wrong, we misconstrued the charter, and that we can select the mayor from among the four. That is inexplicable and it is unacceptable. It plays into all the fears that residents had about a lack of transparency and a lack of honesty. This Saturday, I personally delivered letters to 3 of the presumptive council members asking them, urging them to cancel tomorrow's emergency meeting. Well, it appears they have no interest in changing course. So it is with a heavy heart that I announce that I have no other choice than to seek immediate injunctive action to cancel this meeting scheduled for tomorrow. Now, due to the time constraints, it's not sure that I'll be able to get the motion for injunction relief heard, but I'm going to try my best because that's what the citizens and the residents of Mulberry deserve. Residents in District 5 and across Mulberry have made it clear that they want a city government that operates openly with respect for the rule of law. They've also made it clear that they want leaders who honor both the letter and the spirit of our charter. This is not just about procedure. This is about the trust that people of Mulberry have placed in their government to respect their voice and their vote. And that is nowhere more important than in District 5. In District 5, at the referendum in May, 53% of the votes were against the formation of the city. And this showed their concerns about the transparency and accountability of our city's governance. This agenda to push for an unlawful emergency meeting threatens to reopen those wounds as it suggests a willingness to bypass the very procedures that were supposedly designed to ensure fair representation. We cannot afford to start this new chapter of our city's history on a note of complete disregard for established law. I urge again the presumptive council members to cancel Tuesday's emergency meeting, to respect the process set forth in our charter, and commit to scheduling these appointments at its first regular meeting to be held after District 5 council member has been selected. There is no order of business that they have mentioned that cannot be adequately addressed after the runoff election in December. There is no need whatsoever for an emergency meeting. As elected representatives, the 4 presumptive council members have a duty to ensure that their first act is a lawful one and that their decisions reflect the will and the best interests of our community. Let's start this journey to cityhood off with trust, respect, and a commitment to doing the right thing. Thank you so much.
You mentioned you were seeking injunctive relief. Has that already been, today being a holiday, were you able to file it today or do you have to wait till tomorrow?
Well, I can file it with the clerk today, but they won't get it till tomorrow. So that's why I'm concerned that there's not going to be enough time for action to actually be taken, but I've got to try. And if they're able to get it assigned to a judge quickly enough, we might be able to stop the meeting tomorrow.
You said you personally delivered letters to 3 of the council members elect. What did they say to you when you handed them those letters?
Well, we had to leave them at their residences.
Oh, okay.
And one I was able to email. I had to email as well, but I did not get any response to the email or any to the letters.
I don't know, I'm not, that's all your time. Do you plan on, assuming that the meeting is not stopped and goes forward tomorrow night, do you tend to be there to try to voice your concerns to the council then?
I will absolutely be there. And I encourage everyone else to be there, whether you're opposed to the meeting or not, especially if you're opposed to the meeting, because it's important that they hear all our voices and all our concerns.
Now, Representative Chuck Estration, I reached out to him about this since he worked on this. He seemed to believe that under I think, Section 902 of the Charter that they could do this. I think you've addressed it already, though. believe that is not the case?
I do not believe that is the case. I went over the charter numerous times this weekend, backwards and forwards, and I found no exception that allowed them to call this emergency meeting. And as also stated, it violates the notice requirement of the Georgia Open Meetings Act as well.
Any other questions I have?
All right, thank you again so much. I appreciate you all showing up.